Welcome to VListen. If we listen, we learn. In today's episode, we explore the liability of directors beyond the protective wheel of the moratorium provided under the Insolvency and Bankruptcy Code. Picture this: a company undergoing CIRP with a moratorium under Section 14 of the IBC. Does this shield the directors from legal proceedings? The Hon'ble Supreme Court sheds light on this question through its significant rulings. In the case of P. Mohanraj versus Shah Bros. Ispat Pvt. Limited, the Supreme Court emphasized that during the moratorium, while proceedings against the corporate debtor may halt, actions can still be initiated or continued in the cases of check bounce matters against individuals mentioned in Section 141 of the Negotiable Instruments Act. The court made it clear that the IBC's moratorium provisions apply solely to the corporate debtor, leaving directors under statutory liability. Building on this precedent, the Supreme Court, in Anjali Rathi and others versus Today Homes and Infrastructure Pvt Limited and others, clarified that the moratorium does not prevent individuals from pursuing proceedings against the promoters of the corporate debtor concerning settlements reached before the court. Fast forward to the recent case of Ansal Crown Heights Flat Buyers Association versus Ansal Crown Infrabuild Pvt Limited. The Supreme Court affirmed the earlier stance, permitting the appellants to proceed against the promoters of the corporate debtor despite the moratorium. Now, it's important to run into the facts of this case that delves into the practical implications of these legal nuances. In response to a complaint by homebuyers, the National Consumer Disputes Redressal Commission (NCDRC) directed the developer to complete the project and refund deposits. When the company failed to comply, the homebuyers filed an execution application against the company as well as its promoters. However, due to the company's CIRP, the NCDRC held that the decree couldn't be executed against the company during the moratorium. Further, the NCDRC observed that, in view of moratorium against the company, it would not be appropriate to proceed in the same execution against the promoters who were originally not part of the order but were made party to the execution application. This decision was appealed before the Supreme Court, which ruled that the moratorium, while protecting the corporate debtor, does not extend to shield the directors or officers of the company. The court clarified that proceedings can be initiated against the promoters for execution if they are otherwise liable to comply with the order against the company. Importantly, the court emphasized that the determination of the promoter's liability must be decided by the NCDRC in accordance with the law. In conclusion, the Supreme Court's rulings emphasize that directors' liability persists irrespective of the IBC moratorium, providing clarity on the legal landscape surrounding insolvency proceedings. Join us in the next episode for more insights on insolvency law in India. Thank you for tuning in to We Listen. If we listen, we learn.